Hello, everybody. I'm Phil Brandt, President and CEO at AIM Employers Association, and welcome to This Week at Work.
This Week at Work is the only show about the workplace that offers you front row seats and a microphone, featuring experts in human resources and employment law to bring you practical, timely, and accurate insights so you can more effectively lead your organization. It's Thursday, February 22nd, episode 267. Today, we pivot to a more optimistic outlook of the U.S. job market, exploring the positive movements towards a fulfilling life for both employer and employee demands amid intense competition. Talent acquisition expert Jessica Gibbons joins the show to provide valuable insights into emerging trends that are encouraging for employers with ambitious hiring goals for 2024. Plus, Jessica offers a glimpse into her upcoming Wayfinder session, and we have some great poll questions for you this morning, so get involved in the show. All this and more on This Week at Work.
All right, welcome back, everyone. Hey, Burt, it looks like you're in Hotel California. I mean, have you checked in and they won't let you check out there?
The state refuses to let me leave. They love me so much out here, Phil.
You know, I know you love California. It's your favorite state. Hopefully you're doing well. We appreciate you getting up early and joining all of us here live this morning for that. Are you coming home soon?
Coming home on Saturday morning, thankfully, and I'm out here. Had a round of depositions, a court hearing, and then I'm actually speaking at a conference a little bit later today for the National Restaurant and Retail Defense Association. I'm talking about what to do when the government comes knocking, when the Department of Labor, the EEOC, the NLRB, ICE, Department of Homeland Security all show up at your door and demand to come in. And then also another one that we've added to the mix in recent years under the Biden administration, the Department of Justice. What do you do when the Department of Justice comes knocking at your business?
All right. That's why we love having you on the program. Great experience coming your way. We're going to get right back to you in a minute, Burt. Spring is definitely in the air here while you are out in California. We've had 70-degree weather in the Midwest. It's been fantastic. Cardinals are in spring training, great members of AIM Employers Association. And today, if we're lucky, we're going to have a special guest, senior recruiter Jessica Gibbons is going to be joining us and giving us some insights to what she's going to be talking about at our upcoming Wayfinder event on March 15th. At the factory right here in St. Louis, a very popular event. It's a rock and roll environment for us. Every time we're there, we have a great time. And we will be doing that once again on March 15th. Don't forget to sign up now. We also have one other thing while I'm just giving you updates. We have our first annual Illinois Compensation Strategies for Compliance event coming up on March 26th. It's in person only. It is not going to be simulcast. I know I get a lot of questions about that. Sometimes we're able to do that easier than others, but in this case, it will be in person only, March 26th. It's worth 2.5 HRCI and SHRM credits, and we will have fan favorite Mikey Mack leading the way on that discussion for us. So that is a upcoming event to look forward to. Also, if you attend that event, you will get 4 compensation benchmarking job titles for your organization, and that is a value of $400. So in addition to just getting some great information and learning how to be in compliance with all those crazy things going on in Illinois, you'll get some value for your organization as it relates to benchmarking.
Phil, yeah, darn it, I was trying to get there before you. I was trying to get you to jump to the poll questions because you keep forgetting those. So this time you actually remembered. All right, fine, go ahead.
Yeah, I was getting right to it. Burt, you have done a good job over the years getting me just to follow a script. I know is hard, you know. My attention deficit comes into that, and you know, sometimes I get a little bit off track. Like last week, Burt, you weren't on the program, and I got called out by my friend Michelle for saying the SHIT word on air, and I was, you know, made fun of, and that carried over this week to our roundtables, and people were making fun of me. So I'm not going to say that anymore on the air, but I will say caca. right? I think
I must have
caca
missed a
is
good.
okay.
I must have missed a good show. Wow.
It was innocent. It was innocent. But it just tells me people are listening, and we're going to keep this rated G. We're not going to PG, let alone PG-13.
Well,
I would like to just
we
add in
we might
here,
get a little. We
thank
might
you,
get a little
Michelle.
PG-13. We might get a little PG-13 when I give you some scary news on some of the stories today when we do Lawyer on the Clock. But we'll see.
Well, now that's a good teaser for us. All right, let's get these poll questions and get the lawyer on the clock. All right, so our poll questions for today is, what do you see as the biggest challenge for filling open positions in your organization? So this is for you and your business. What are your biggest challenges in filling open positions? That's question number one. Poll question number two is, what is the first thought that crosses your mind when you hear there is an open position at your organization? That's going to be an interesting one. Don't use the SHIT or caca word in those examples, please.
Keep it clean.
And then
No other
what's that?
languages either. No other languages.
No other languages either. I'm afraid this one's going to take a life of its own, Nick. And then the final one is, if you could hire anyone to work alongside me, who would that be? And that's alongside yourself. If you could hire anyone to work alongside you, who would that be?
I got one for you.
Someone
it's
like
easy.
Burt Garland. Like, I look forward to working next to Burt every day.
Phil, sorry, it's not going to be you. It's going to be my puppies. If I could hire anyone to work alongside me, it would be my two dogs.
Your two dogs. I have seen in the background that your dogs are beside you. Yeah, that's when they're not running the neighborhood, Burt.
Exactly.
Clearly, it's after Valentine's Day, and we've decided not to include our wives.
She wouldn't want to work with me. I promise you that.
Oh, I get reminded at home all the time. I am not at work anymore. All right. Let's see. Just in case we get we do get Jessica to join us, and I know she's out busy, and we're hoping that she's going to. I do want to talk about this this meme that we have for Philbert's Forum before we get to Lawyer on the Clock. Can you see that? Is that up on the screen?
Yep, we got it for him.
All right, so there you go, Burt. I thought you might enjoy this one, right? Back in the day, as managers telling someone we're family, we're one big family. Meanwhile, we're shaking hands and we're going, me who has applied for 30 other families, right? I just think that's a perfect one. We're saying two things out of the side of our mouth. Over here, we're going, we're family, and then we don't treat people like family. And employers are going, maybe I'm going to go work for some other families instead. But great meme. I think it does describe the time of the sign of the times. And maybe when Jessica joins us, we'll get a little further into that meme. All right, Laura, are you ready?
I am ready, Phil. Let's go.
All right, Nick, pull that lever.
All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
So the first one I want to talk about today, this is going to take us all the way back to 2022. I have to be a little bit careful what I say about the case because my firm did represent the company, the employer, Home Depot, in this case. And just yesterday, a 3-member majority of the National Labor Relations Board, there's only 4 people on the board right now. There's 3 Democrats and 1 Republican. And in a 3-to-1 decision, this board majority reversed an administrative law judge's decision from June of 2022 that held that Home Depot did not violate the National Labor Relations Act when it told a worker that the individual could not work while displaying a Black Lives Matter message on their apron. So again, the board reversed this administrative law judge's decision and said that Home Depot now did violate the National Labor Relations Act when it instructed this employee not to wear the Black Lives Matter messaging on his Home Depot apron. So very interesting case. This one's going to definitely, in my opinion, be appealed into the court system and out of the National Labor Relations Board. The majority said that the employee's protest was protected activity under the National Labor Relations Board, under the National Labor Relations Act, because it was, quote unquote, a logical outgrowth, end quote, of earlier group protests of racially discriminatory issues at this Minnesota Home Depot store. So the board found a way to tie the Black Lives Matter messaging on the apron to prior protests about working conditions at the Home Depot. You'll recall, Phil, on the program, I've talked several times that realistically, Black Lives Matter messaging or any other political type messaging is not going to be protected concerted activity under the National Labor Relations Act unless the person can tie that messaging to their terms and conditions of employment. And while in this particular case, from the decision, it appears that Home Depot said that this was not tied to any prior protests, and the facts of the case really did not show that the Black Lives Matter messaging was tied to any prior protests of working conditions, the board developed this new logical outgrowth standard to say that this was protected activity. So this is a very, very interesting decision. I think employers need to pay attention to this, and it shows what we've talked about a lot of times on the program here, is that what business really can't stand is this pendulum moving back and forth every 4 years. And that what business wants to know is what the rules are. For better or for worse, just tell us what the rules are so that we could develop our policies and procedures and manage our business in a way that complies with the law. But when the law changes every 4 years or so, it gets very difficult for business. So this is a really, really big decision. Like I said, again, this case is definitely going to be heading into the court system, in my opinion, or into the appellate courts. I don't have any inside information from my firm. I haven't talked to the attorneys involved, but the point is that in 2022, Home Depot won the case before an administrative law judge at the NLRB. The board just reversed this case yesterday, and I think the next step is going to be the DC Court of Appeals.
Yeah, I'm with you. If we get to this point where we start to get a little bit ridiculous and we're really all just trying to either earn a living and or, provide a service to customers, and then we get ourselves out of control and in these really tricky situations for all the wrong reasons. Right or wrong, we're at that point, we're not there, working and staying focused on, the job at hand. It just surprises me that this is still going on after all this time, what seems to be a really small issue on the surface.
Well, and this, and it seems to be a small issue, but it's really a huge issue. I mean, the case goes back to February of 2021. In the Black Lives Matter protesting that the employee had on their apron followed the George Floyd incident up in Minnesota. And so this quote unquote logical outgrowth standard that the board developed and adopted here really is going to be difficult for employers to manage. So while it sounds like a small issue, it's going to be very difficult until this works its way through the court system.
Yeah, particularly as we're coming into another political season where we're likely to have some of these flare-ups occur again, as they are, often politically motivated. But let's move off of that topic, Burt. I do appreciate you following up on that a few years later. I think that's great diligence on your part. Thank you for that. What else you got for us there, lawyer?
All right. Well, I know that Nick in his lead-in today was talking about the optimism in the job market and all of that, and an optimistic outlook of the U.S. job market. Well, I'm going to throw a little bit of cold water on that because job cuts, I want to talk about job cuts and the impact of job cuts on the remote work world. And some of the latest data is showing that job cuts really are sending quite a chill through the remote work world. The in-office perks didn't lure people back. All staff emails telling people to get back, warnings telling people to get back. None of that worked. But what is working is layoffs. Layoffs in the white collar sector seems to be getting people to return to work. those layoffs, as we've talked about on this program, there's real disconnect in the economy right now over where the jobs are. The restaurant and retail sector still can't hire enough people, but the white collar jobs right now, that is where the jobs are. There's company after company doing reductions in force right now. And so you've got a sector of the workforce that's experiencing layoffs, and where the jobs are, it's not where these people want to go work. And so there's a big disconnect there. And these layoffs really have been increasingly targeting remote workers. And this is something that remote workers probably really need to factor into their calculus of how important it is for them to work at home. There's
Hey,
a
Bert,
study.
I just need to interrupt you there, because one
Sure.
of the things that we saw happen with remote workers was when remote workers went remote and they moved away, and many of them were female workers. And at that point, then they started to change compensation strategies and saying, okay, well, you're moving out of our high cost of living in Silicon Valley and you're moving to Nevada, where it's a much lower cost of living and the wage is different. And then they started changing the wage structure, and they got themselves in trouble a little bit around maybe some unfair treatment in that case. I think the concern could be the same if my remote workforce is predominantly female, and then I start laying off remote workforce in a way that's not based on performance or otherwise necessities for that particular job. Is that a concern in your mind? Is that something you can look into your crystal ball and say, hey, be careful with this? I know you're going to say be consistent and it depends and all that stuff you always say, that caca you always say, but yeah.
Be consistent and be fair, of course,
Yeah.
Phil. Yeah, I don't see this really as creating a disparate impact on the female workforce versus the non-female workforce. I think it's really targeted at people. The category is who's a remote worker and who's an in-office worker. And there was a study by an entity called Live Data Technologies. It's an employment data firm that analyzed the status of 2 million white-collar workers. And they found that the share of fully remote U.S. job postings on LinkedIn dropped more than 9 percentage points between the beginning of 2022 and the end of last year. And across Fortune 100 companies, the average in-office attendance requirement is now 3.1 days, according to a real estate firm called JLL. And so I just, again, raise this from the standpoint that that layoffs are having an impact on remote workers, and that may be the thing that finally gets people back into the office on a more consistent basis.
Well, I can tell you there is a thing called rush hour traffic now back here in St. Louis every morning, every evening. So rush hour traffic is definitely back, if that's a sign of people returning to the workplace.
Yep. All right. And the last one I have for you is just a reminder, and I see that Jessica hopefully is on and able to hear us. But the last one, I just want to remind people that March 11th is quickly approaching. And March 11th is the effective date of the U.S. Department of Labor's new independent contractor rule. That means that barring some sort of a court order blocking the rule, employers are going to need to come into compliance with this new rule. And that means that some workers switching from independent contractor status to employee status is going to have to take place. And employers need to be preparing for this. Phil, we can certainly talk about this in more detail probably next week.
Yeah, I do want to just talk about a few things on this if we can, Bert.
Sure.
And when I think about, first of all, I'm not getting a lot of questions about this, and that's always a concern to me.
I agree. I'm not either, and I think that employers are not properly preparing for this. I think employers are relying on it has been challenged in the courts already, but no court has put a restraining order or a stay on the implementation or the effective date of this rule yet. And so I think employers are kind of counting on that happening. And until it happens, I think employers should proceed down the road for at least analyzing and conducting internal audits, et cetera, to see if these folks really are independent contractors or not.
So maybe we can just spend a few minutes and let's take it from, the broad, obvious perspective from that standpoint and narrow it down into a few other examples. So we talk about the gig economy, and that's not the majority of the organizations in which AIM represents.
Right.
And works with. So, talk about Uber drivers and Lyft drivers and, door dashes and all these types of things. Let's not focus there. Let's start with.
So Phil, yeah, let's not focus there, but make no mistake about it. This new rule is designed to target those industries. So I agree. Let's not focus there today, but it's going to decimate that business model. But go ahead. It's going to have other ripple effects well beyond the gig economy.
That's my concern, right? That was the target when we've been talking about contract workers for a long time. For 12 years I've been in this role, it's been a conversation depending on who the political leader has been in the seat of president. But let's think about it like this. So let's start with your traditional temporary workforce. I call up the temp agency and I have employees coming, temp employees coming into the workforce on a regular basis. That industry will definitely be affected in ways by this. If I just say I need a temp to come in and do some filing for us for the next 3 weeks.
So let's chat about that, because now I think you're really kind of mixing two different concepts here, and that is, it is partially an independent contractor analysis, but that gets into another hot area of enforcement among the administrative agencies, and that's joint employer. Now, what you're talking about is you call up a temp agency. That temp agency in and of itself is an independent contractor of yours. There's not that much risk that those employees of the temp agency are going to be considered employees of your company under an independent contractor analysis. There is a high risk, though, under this current administration, that they could be considered employees of yours under a joint employer analysis.
Okay. Now, when we take that one step in, and now we have a temp agency that only works for our business. Right. Yes.
So if you have a temp agency or a temp agency that only works for your business, again, I think that under those circumstances, if the temp agency is a temp agency of one person, and that person does nothing but work for AIM, then I think that there's a high possibility that you would have had that temp agency or person misclassified as an independent contractor versus an employee. But if the temp agency is a real bona fide temp agency that provides employees, it has more than one employee, and it provides employees to a range of businesses, or provides their own employees to a range of different businesses, then I think there's a possibility, even under this new test, that they would be truly independent contractors or employees of that temp agency.
Yeah, because I do see it in shapes. It looks like this to me. My brother-in-law, I'm the owner of a business. My brother-in-law has an IT firm, and he's got 2 or 3 employees, but he only works, if that firm only works to supply our IT services. Or we have a small shipping or distribution or warehouse management crew who only works for our business. And that might be just a gray area to go in and dive a little deeper and just make sure you're evaluating the risk of that.
Well, so let me give the factors, because I think we want to talk about the factors that are important here. Right now, the Department of Labor and frankly the other administrative agencies, they sort of use what's called a weighted factors test, where control is the most important of the factors. Who actually is in control of the people who are doing the work for the company? Is it you as the employer, or is it the independent contractor, him or herself, that's really in control of the work? And what they're really going to be focusing on now is what's called a totality of the circumstances approach, and it's based on 6 factors. And of course, that first factor is which employer controls how the work is done. So you do get back to that control factor. The other factors, though, are the worker's opportunity for profit or loss. So in other words, if it is an independent contractor and they set a rate that they're going to charge you for this, that person has an opportunity for profit or loss. They may do great on the independent contractor assignment, or they may do poorly. The next element is the amount of skill and initiative required for the work. The fourth factor is the degree of permanence of the working relationship. The fifth factor is the worker's investment in equipment or materials required for the task. So Phil, that's an easy one. If you think about, you're going to hire somebody to do some maintenance on your or on your computer system, or to work on in your training room where you have all of the IT equipment and everything. AIM is not in that business, and you don't have all of that. You may not have all of that material or all of that equipment needed for that purpose, and so the worker might have to invest in equipment or materials. But here's the big one that I think is newer and really going to impact this area, and that is the extent to which the service rendered is an integral part of the employer's business. Okay, so let's focus on that one. Okay. Let's take that same IT example. So AIM is not an IT company. You don't provide IT services for your members or anyone else. So if you hire somebody to come in and perform IT services for AIM, yes, it's integral to the operation of your business, but it's not something that AIM otherwise does. Okay.
Right.
So you're not providing that service to anyone else. Now, let's say, for example, AIM hires an independent contractor to supply to one of its members to conduct a harassment investigation. Okay. Now you're into a different situation, because that is AIM's work. That is integral to AIM's actual work. And so that does sort of beg the question then, whether that individual is still an independent contractor of AIM, or is that person an employee of AIM? And then you take it to a whole nother level. Is that person an independent contractor of the place where they're going to do the harassment investigation, or are they an employee? And so again, very important that people start recognizing that this is coming down the pike. Again, on March 11th, this goes into effect, absent a court order putting it on hold.
Absolutely. I think there's some really interesting things there for us to consider, because those things are happening all the time. And I think we have to look at what checks are we writing that are coming out of the finance department to whom, and just kind of look at that to determine, do we have risk with that set of contractors or individuals that are working with us, and how do they stack up against the tests that you just provided? And I think that's going to be the starting point for organizations to look at, okay, who are they? Because sometimes we just lose sight of that, right? We've worked with someone in a way so long, we just kind of lose sight of that. Burt, I want to draw our attention over to the chart, but the lack of qualified candidates definitely leads the way for responses to our poll question. And there's no doubt the reason that we have a lack of qualified candidates is really this reason on this chart behind me. And I know I go through this chart all the time with our members, but it just flattens out the population of those individuals that we're looking to hire, and started in 2020, coincidentally with the COVID period. But there are just not many people. And so I broke it down mathematically this week for some of our roundtables. And so what it really means for us, where we've been in this environment growing our working population at a rate of 20 million people every 10 years. That's what we've experienced since 1950 here. And we can see it's been growing and growing, and then it just kind of flattens out. What happens there is now we're only going to grow that same population by 5 million people over the next 20 years, right? So they're already they're 15, they're already alive, because it starts at age 15 is where we start measuring that. So we can count those belly buttons and move them ahead and say, we know where we're going to be for the next 15 or 20 years. So what that means when I break it down is, if everything was equal across all of the states, which it is not, there's some states that have more puts and takes than others, but if every state got the equivalent distribution each year of the available new talent in the age band, what that means for the state of Missouri, for the county of St. Louis, is that you would get 5 more people in 2024 to recruit from. That your recruiting population, that working population, is going to grow by 5 people every year. And that is what I think what people are saying by a lack of qualified candidates, because obviously we need more than 5. And that's where, at the same time, when we look at the cooling off that you were referring to in the layoffs, I'm going, we have to drench. It's not just a cooling, it's going to take a drenching to create enough unemployment to fill the job gaps that we have. And that is what I was hoping to get into with conversation with Jessica. I know she will be at the Wayfinder Summit. We'll try and squeeze her back into the program, but those are some serious figures that we're contending with when it comes to availability of talent, and why I think people are saying in such a high rate that their concern is talent availability. Anyway, that's the end of the program. That's my soapbox. It's not a bunch of caca, that is for sure. It's facts. And we will be back on the air next week at 7:30. We'll see you then. Burt, I hope they let you out of Hotel California. Until then, you go out and be good to those people in California. They need your help. Bye-bye.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues, forward our invites, share the link, aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment. LinkedIn, YouTube, Spotify, Apple Podcasts, we're everywhere you are. Don't forget you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.